that is crazy. Why is that crazy? It's crazy because when an error, and the prosecutor admitted the error, right? He admitted that he made a mistake. The time to fix that is in the moment. They just heard it. You need to tell them when it happened.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your very own personal board-certified criminal defense lawyer, coming to you with my Irish cufflinks today, so graciously gifted to me by me old fiancé. Did I say fiancé? Why was that hard to say? It wasn't, because I'm madly in love with my fiancé. Thank you for the cufflinks. I'm such a goof. You know, when you're in love and you're happy, you're a goof. That's what I am. But anyway, today we're reacting to just kind of a compilation of updates on the Karen Read case, just to get you up to speed and give you my take on this case. And I just can't believe they haven't negotiated this case. I mean, maybe she won't take anything, and maybe they won't offer anything. But this is a case that should have been negotiated. Both sides have issues on this case. But before we get to our in-depth analysis on Criminal Lawyer Reacts, a channel created by our former content genius, Michael Rivers, God rest his soul, as I think about him every day. Before we get to that, this is brought to you by, say it with me, AskALawyer.com. AskALawyer.com is a great way for your grandma who's pissed off at you because she's living in your basement, picking her toenails and feeling like she's abused. So she calls AskALawyer.com to find out, does she have a claim for elder abuse? Or maybe you have somebody else living in your basement that you're renting to and they have a real estate complaint. Do I have a landlord-tenant issue? Do I have a complaint against my neighbor who I sold a car to, but he won't transfer the title? Whatever your issue is, go to AskALawyer.com. They have lawyers who only charge you like $49 for an initial consultation, and they're real God-fearing lawyers. They need to be God-fearing? Well, they are, and they're there, and they're live people. But here's the thing. If you're doing your own case and you're doing your own research, or you just want to find some shit out, go to AskALawyer.com, and they have an AI component that's trained in on all the laws of this country based on all the 50 states and the federal statutes. So go to AskALawyer.com. They're a very loyal sponsor of CLR, and they're also the same people that brought you eForms and eSign. So you know they're a reputable outfit. Okay, there we go. That's our obligation for today. So let's just talk about what happened here. Let's get a little recap of what we're analyzing with the Karen Read case. Karen Read was out with her boyfriend, and she was out with her boyfriend at a bar. They were drinking. She drive to an after party, and then who knows what happens after that. What happens after that is just up for grabs, because one side's saying one thing, another side's saying another thing. So the defense's theory is that he went in the house, the boyfriend went in the house, she took off or did whatever she did, and then they beat the shit out of him in the house, and then they leave him outside to die. The state or the prosecution is saying that Karen Read accidentally ran him over because she was drunk and killed him, and that's how everything got happened. There have been so many shenanigans in this case, so many, we have somebody Googling how long it takes somebody to die of hypothermia. Why the fuck would you do it on that particular night? Huh? And then you also have Karen Read making statements saying, did I run him over? You ever see My Cousin Vinny? Where he says, well, did he ever admit to the crime? What other evidence do you have? Well, he said, I shot the clerk. And then I asked him again. He said, I shot the clerk. Well, if you watch the actual clip when he says, I shot the clerk, he says, I shot the clerk? I shot the clerk? In other words, what the fuck? And then once the deputy leaves, he goes, no! And that wasn't something that the deputy testified to. And the deputy was being truthful, right? Well, in this case, when she says, did I run him over? Oh my God, I ran him over? Oh, she's contemplating it. She's not making an admission as such. Anyway, let's kind of go through some of this thing. There's this accident recreation, and created by the defense, and then some created by the state. So let's just take a look at see what we have here. So it was just brought to my attention to remind you guys that of his injuries. So he had some facial injuries. He had a skull fracture. He had, if you remember, the dog bite kind of injuries that he had on his arm, but no broken bones on his arm. And certainly not where they say this had occurred. He had a fractured rib. I mean, he looks like he got the shit kicked out of him.
Once it breaks, it's already reached a common velocity to the taillight.
Okay. Can we go ahead and go to the next slide, please?
These are powerful images because it shows you kind of the velocity of what would have to happen for that taillight to break. I mean, those taillights don't break like just by tapping on it. It has to have some force. And that force, would that cause the arm to be broken?
What do you note about this impact?
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over kind of the arm and the taillight there.
Do you note more damage or less damage to the taillight at 17 miles an hour versus the 10 mile an hour test?
There is more damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the taillight enter from the left, impacting the arm at about 17 miles per hour.
So these are really important simulations because we don't have anything on camera. You know, normally there's things on ring cameras, there's things on traffic cams, there's things on body cams. Usually we can see, and we're so used to it now, right? People have their cell phones out, but we don't have that here. So that's why these images are very powerful.
Okay, go ahead and play it. Can you describe the decoupling that's shown here?
Absolutely. So as you can see where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right? This is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end of the stroke.
Understood. Next slide, please. What are we looking at here?
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct, not real time.
Okay. What do you know?
And 17 miles an hour, why do they say that? Because that's the theory of the prosecution. And that's how fast their expert said he was going, or she was going. And you can see, you know, if you're going 17 miles an hour and you get hit by a car, it's hard to say if you would have a fracture on your arm or not. And so essentially what they were doing here is they were going, you know, starting at 2, 4, you know, whatever the intervals were, to get up to the point where, you know, you'd have the taillight break the way the government said it broke.
Note in terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving now at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10 mile an hour test, which, again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide. What is this a picture of, or pictures of?
This is a side-by-side comparison showing a depiction of the 17 mile an hour test impact to the test taillight, comparing it to that of the subject taillight.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Slide 45, please.
So you hear that term, you know, to a reasonable degree of scientific certainty. You have to have these generally accepted scientific principles when you put evidence in. So like when you have a medical expert for like a medical examiner and say, is that your opinion? Have you developed an opinion within a degree of medical certainty? And that's what he's talking about there.
What is this?
You're looking at photographs post-test of the sweatshirt that the ATD was wearing at the time of the impact.
Is this the 17-mile-an-hour impact?
Correct, yes.
Did you note any defects in the fabric of the right arm?
There were no punctures, holes, or fraying of the material during this impact test.
Based on this testing that you conducted in this case, is the damage that you saw of the shirt that John O'Keefe was wearing consistent or inconsistent with the shirt that's on the ATD?
It was inconsistent compared to the sweatshirt that Mr. John O'Keefe was wearing.
Based on that, do you have an opinion or a conclusion as to whether or not the damage on Mr. O'Keefe's clothing was consistent with being struck by the right rear taillight at 17 miles per hour?
It is inconsistent.
So now you have competing experts. We're going to play the expert for the government, but the difference between how much they paid these people, I mean, I think they paid like $60,000 or $70,000 to this defense expert, and if the other guy's into the government for like several $100,000.
Temperature accounted for?
Yes, every test had a new set of quarter panel taillights, as well as liftgate taillights, and even in the test where the taillight in the 50-mile-an-hour test where the taillight was not damaged, we still put on new taillights. We did not repurpose or reuse any of the taillights.
Okay, thank you. If you could play this for us, please.
And the reason this is important is because the body mechanics of what happened after he supposedly was struck. And if he was struck like this, clearly he's not under the vehicle, And if it's not consistent with what he has for injuries, it's an issue for the government.
What are we looking at in this video, or in this picture?
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer. The line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
So what I'm confused about, honestly, is if she's driving, right? She has to be driving because that's what the allegation is, right? So if she's not driving, there's no case. So she's driving. So she's on the left side of the car. He's ostensibly the passenger. And so they pull in together. Is he riding with her? Or did he drive himself in his own car? I don't think that's the allegation. And he gets out. Did he go around to the back of the car? Is that the allegation? And all of a sudden she backs over him? And either way, to me, it's more of a manslaughter case than a murder too.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Sustained in that form.
Were you able to reach any opinions or conclusions as to whether the damage to the subject tail light is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
What are we looking at in this series of photos?
So these are photographs depicting, excuse me, the test clothing. Again, prior to the test, there were no holes or damage to the sweatshirt. That was the same post-test. We did not see make any observations with respect to any fraying, holes, punctures to the material of the sleeve.
Was there any damage whatsoever observed on the right sleeve of that ATD?
No.
So, I mean, this is why these body mechanics are so important, because you don't have a fracture of the arm, but you got a fractured rib. Could that have just been caused when he hit the ground? But, you know, it's unknown. There's just not enough information.
Time slows down every minute with you. I'm forgetting all the lies that they
Let's see. So this is some funny shit. I guess Robert thinks is funny. Let's see. When you try to confess your love to Crash Daddy and everything goes wrong.
told to me, you're the sign I was missing, the love that was for.
I think Robert thinks he's cute.
Sir, you're pulling something out.
Calculator. I thought you were going to ask
Hey, now here's a smartass states expert.
me numbers, do calculations.
All right. We need to do, if we're going to do that, we need to do it with the court's permission.
Sorry.
So if you,
I don't know.
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
So if somebody's testified quite a number of times, if you're trying to testify, you can't rely on other things other than your own memory unless you get permission from the court. Dr. Dinglefuck, would it refresh your recollection to look at your report? Yes. Your Honor, may he look at his report? Yes. So that's what Dinglefuck is doing. Or I mean, this expert is doing.
Thank you.
You're welcome.
Ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
You just got the
Hold on, Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yep.
computer.
If you testified in a lot of these things, you're getting paid $700,000. You should know the fucking court rules.
Let me close it. Sorry. I was trying to answer his question.
was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
See, he's nervous. This expert is nervous. And he wants to be able to kind of do the cheat sheet thing. And the defense wants to make it known how little this guy doesn't know. We want to make him look bad.
Closed. Yes.
Would he open?
So it's just, did you just turn it off?
No, but I will. I closed it.
Lunch break, I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up.
And smartwatches. And he's got those glasses on that have a screen inside there, the Google screen. And, you know, I think he had some Elon Musk memory chip put in his fucking brain. So give me a break.
And Dr. Welch, we're going to ask you to not turn on your computer yet.
Okie
Thank you.
And Your Honor, if I could, smartwatches that are receiving text messages during his direct, if we can make sure that that does not occur.
I can get my email. I'll take all the time.
Okay, or just don't look at your watch.
Okay.
Okay.
Thank you, Your Honor.
And then I have backed up sideways, side shuffled into the Lexus with my arm out, see what the damage pattern looks like. Or basically where.
That looks pretty scientific, doesn't it? Just roll onto that thing.
Someone of Mr. O'Keefe's height's arm would contact the rear taillight. So then what you see is I've shown the photographs again. I show the paint transfer onto my arm. The yellow grease paint on my hand was to show where my hand would hit the taillight.
So the thing I don't like about these, I like the defense simulation better because it really is more scientific. It's about the impact. How much impact does it take for this taillight to break, number one? And number two, what do you see as a result of that? And they show real impact as opposed to him putting fucking paint on the taillight and just brushing up against it. What does that tell you? Nothing.
And so just kind of me walking slowly sideways into it, the approximate location of the taillight, and I'll line it up with the broken taillight. And
Fucking A. I mean, why does the judge let this in? I mean, this is just so not scientific at all. It just, I mean, there's so many variables, and, you know, this guy was drunk. It was snowing out. I mean, how do you know how this guy was or wasn't?
the second lines up with the approximate location of the lacerations.
Oh, it just happens to line up perfectly. Because, I mean, let's just rewind this just a little bit and just watch how he fucking does this.
Sideways, side shuffled into the Lexus with my arm out, see what the damage pattern looks like.
I mean, how do you know his arm was like this? I mean, maybe his arm was straight down. I mean, it's just so nonsense.
Also, that's what they have to do to prove that that's where the cuts on his arm came from.
Yeah.
So I'm trying to see if there's any correlation between all those.
All right, so the last witness was your witness? Is there a reason?
That was unimpressive, by the way.
This is a separate issue. I'm asking Mr. Leslie to address the one on these.
Okay. What do you want to tell me, Mr. Leslie?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury.
Why does he have gloves on? So to move for a mistrial based upon misconduct to the prosecutor would require dismissal of the charges with prejudice. That's what happened in Alec Baldwin's case, because they fucked up the discovery. They didn't disclose a lot of things. And so when the government screws up, there's got to be a consequence, and the consequence is dismissal. But it's a very, very, very rare thing that's used.
And what I'd like to do, Your Honor, this regards the hoodie. In this regards questioning and representations and questioning by Mr. Brennan.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay.
Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now?
Well, that's why he's got the gloves on.
It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Leslie.
So here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist.
So basically what they're saying is, you see the back of this shirt? This was shown to the jury, and it wasn't explained to the jury that these holes were not caused by the car accident. And they could be misled that they are. And in fact, they were cut out probably for DNA purposes, or to see if there's any blood-like substance or any kind of other thing, even, tar or, something from the driveway or hair or anything from that's of evidentiary value. So they cut out, samples. That's what he's talking about.
Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards?
That's a fucking problem, because if the government is, they know how the holes were created. They were created by a criminalist, who's just taking out samples, a forensic scientist.
Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind. And
that would be a problem if that's true.
In that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What
okay.
we have is two documents to show that. I will note Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence.
So there's a couple remedies for this. One is a mistrial, and which, if the judge would grant it, a mistrial based on prosecutorial misconduct results in dismissal of the charges with prejudice. Or she could say, okay, I'm taking that piece of evidence out of circulation. The government can't use it. And I'm going to instruct the jury that the government has misled you, and this piece of evidence is no longer in evidence. That's something that she could do.
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie.
So you've got two documents. You got an intact sweatshirt, and then you've got pictures of the cutouts. That's what a shitty thing for the government to do in this case.
Are specified. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see, point out to me where it says, where it shows the back.
This is the back.
So you can see the back of the hoodie. That's the back of the hoodie head.
You see this lady with the thing on her? I don't really know how those work. I've never seen one before. I've seen it in the movies, and you see that. Basically, what that is she's talking into a microphone, and it's quiet so that she can take down everything everybody's saying. It's another form of court reporting.
And then you can see the variations.
What could be more egregious? What could be more misleading?
I don't think yelling like that is really a good thing to do. What could be gained by what he is saying?
Than that. And what could be more important for a context than the alleged collision that never occurred?
It is outrageous. It is absolutely outrageous when you see something like that, but make your point. You don't have to yell.
Never occurred. That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
It wasn't really. I didn't do it on purpose. I'm sorry, Judge. I made a mistake. Well, when you make a mistake like that, it's fucking misleading. You know, I mean, you can't make mistakes like that when the stakes are this high. Sure, maybe if it's a case about whether or not you pissed on a sidewalk, but this is a homicide.
And so I think what should happen is there should be a curative instruction. There should be
a curative instruction is where you tell the jury, okay, you remember that pink elephant that ran through the room and it destroyed everything? Try not to think about it. You can't think, you know, I mean, you can't unring a bell, right? You know, when somebody does something, you know, if I tell you right now, don't think of a huge black man naked. What just immediately came to your mind? A huge black man naked. I mean, you can't stop thinking about what I just told you. Now, don't think about it. Don't think about his afro. Don't think about his sweaty skin. Don't think about him running through your kitchen and stealing all your celery. I mean, you just get an image of everything I told you not to think about, right? So you can't not think about something you just saw. That's why the curative instruction, and there's all kinds of research on this, the curative instructions don't fucking work.
Stipulation, the court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician.
A crab lime. Here's the thing. When you're caught out like this, you get nervous. And he's probably nervous. I made a mistake.
This was done inadvertently but should not have been asked. The court should strike the questions and the answers.
But I mean, fucking A, it's not a mistake because you know how those fucking holes were made. Could those holes have been made by road rash? I mean, you knew that. I mean, it's not like that's a critical piece of evidence. What the decedent was wearing during this supposed crime. And your criminologists have made cutout holes of it to take samples. And now you're saying, could that have happened when he was struck? Come on.
And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
I'm not going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B, 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury. and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they...
I sort of agree with the judge's ruling on this. I don't think it's... I mean, once you tell the jurors, oh, the state fucked up here, and really this is where they came from, I think it's a nothing burger, honestly. I don't think the jurors are going to say, oh, but, you know, it really does look like he was hit and dragged. You know, they're not going to think that. So, you know, and if it was an innocent mistake, which I think it's just how the fuck could you make that innocent mistake? You know what that piece of evidence is. This is the second time you're trying the fucking case. This isn't the first time you're trying the case. But I mean, and here's the unintended consequences of this supposed mistake. Now you can't really trust what the government is saying. You can't trust their case. So it does kind of hurt their credibility.
perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022.
So I think that was a measured response by the judge. I mean, I don't think anybody's going to really win or lose the day based upon that. But it does hurt the government's credibility. So now let's look at rather than go through another long, arduous pieces of trial, let's kind of rip somebody off. And I'm not rip anybody off, but let's just see how others are reacting to some of the news. So let's go to Jed Megan, Nerdy Pink Panda.
This is a circus. This whole trial is a circus. We come back from break after Bev denying.
So is your eyeshadow. Sorry. Look at your fucking eyeshadow. I mean, it's like, should I go or not? It's orange. I mean, is it red or is it yellow or is it an orange? Anyway.
The mistrial, and then we put on the private investigator who went to Princeton, who has a law degree. He explains that he was a last-minute replacement because the original private investigator actually had a medical emergency, so he just last week went out and did these measurements. Then we get sidebar. We think they're coming back. Psych, sidebar. Then we come back from...
Okay, I would like to have her do some tequila with me, actually. No, not really.
From the sidebar, lights go out, this picture gets up on the screen. This feels like the natural place for us to have lunch. So then the jury goes out to lunch. By the way, really curious why the garage is redacted. This is bizarre. And instead of having lunch, we have our voir dire of Dr. Lopasato, who makes it pretty damn clear that she is a forensic pathologist and a medical examiner.
You asked to make a determination about the nature of the wounds specific to his right arm. I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
The mere nature of her profession is figuring out what these wounds are. And she makes it incredibly clear that not only is it part of just her basic training, not only does she make it clear that she has extensive experience with dog bite wounds, but within the last 2 years, she testified in a federal trial of...
So the problem that I think what they're going with this is the judge denied the defense the ability to present this testimony. And you have a forensic pathologist who's had like 50 to 100 dog bite cases that were death related and had and has done thousands of autopsies. And so I don't know why the judge disallowed this testimony.
About dog bite wounds that a police officer dog inflicted. And Brennan wasn't even trying. Everything that he was asking her was like, yeah, that's correct.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, I've had many cases where there have been dog bite injuries.
And so Brennan decides to try and attack her classes, her seminars that she takes.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was regarding wound pattern recognition?
So here's the thing. If the judge disallowed this testimony, that is a definite issue for appeal because it's critical. And because it's an alternative perpetrator, the dog bit his arm, right?
Then Bev makes her inquiry about her experience, and we find out that Jackson vastly underestimated how many autopsies she's performed involving dog bites.
Involved in autopsies with dog bites?
Yes.
How many?
I've done thousands of cases, probably 50 or so, and it's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
So what this is what they call voir direing of a witness. In other words, an offer of proof. And it's to have the witness get up on the stand. The jury is not present during this. And both sides question the witness to see, the defense puts them up there, and talks about the credibility. And then the prosecution, because it's a defense witness, gets up there and tries to say, this person's not qualified, blah, blah, blah.
When was the last one?
Let's see, probably 2 years.
And yet Bev still has the nerve to deny it on the stupidest and the most thinnest of premises. And I don't know about you guys, but she was off when she came back. She was nervous. I don't know. Look.
Regarding Dr. Laposada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Daubert requirements have been made.
So Daubert is it's a case, and it's a case that talks about what you need to have to be qualified as an expert witness.
Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So,
That is ridiculous. Just a little bit I heard. Here's the thing. A judge has got to give the defense a little bit of latitude on presenting their defense. You're denying the defense a constitutional right, the right to a defense. And I think that witness is amply qualified.
Based on that, she cannot testify to the dog wounds, and I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME.
That if she's convicted, that for sure will be an issue on appeal. So now there's some other rumors about who's she talking to in her smartwatch. Let's see. I don't know anything about this. What is she doing there? That's just odd. I mean, if she had a smartwatch, is it activated and she's actually talking to somebody on the smartwatch? Murder mystery continues. I had one case where we had just done our opening statements, and the judge thought he was just sending Facebook messages to his friends or somebody, but he actually posted this shit on Facebook that he thought my client was guilty as hell and blah, blah, blah. And it was a court trial. It was supposed to be a flipping court trial. And he got in a lot of trouble for that. It went out to everybody as he's hearing the evidence, saying my client is guilty. Before, he's supposed to remain, non-biased, and he said this poor witness and blah, blah, blah. And, I don't know how you could do that.
Oh man, things are not looking good for the prosecution. It seems like Bev made her ruling at sidebar, not in open court. But it looks like Dr. Laposada was allowed to talk about animal wounds, just can't specifically say dog wounds.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claw marks?
Yes, it is. Very much.
Thank you.
So they slipped it in anyway, and you don't hear an objection. So that is pretty tricky.
But on top of that, she not only said that he died from blunt force trauma, but
Discrete vertical scraping of the skin You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here.
Yeah, she says the pattern wounds are not consistent with falling backwards and hitting your head on grass. She also explained that he didn't have hypothermia, and in fact, you can't even look to the pancreas in this case for those clues because of the CPR compression machine damaging the pancreas, that you have to look to his stomach for the indicators, and there were no signs of it. Plus, he had no signs of frostbite. Then when she was asked if the wounds were possible with a collision with an SUV, things got spicy.
So this is what happens when you don't have a job and you can just sit there and watch the fucking trial, which I was in trial for the last 3 weeks, in a RICO trial. And, this is, but thank you for letting me catch up on what's going on in Karen Reed trial.
See, first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break. So I'm going to strike that next.
Do Mr. O'Keefe's patterned injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
That's powerful.
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that. But you know what? The jury heard.
That's a fucking problem, because I think that's reversible error for this judge to disallow that. I mean, this is a medical examiner. This is somebody who's a forensic pathologist who's got thousands of cases under her belt, hundreds and hundreds of cases, 125 or so that she's been associated with animal bites. More than qualified.
They heard it. Strike all you want. They heard it. I wonder if we're going to start seeing favorable jurors excused any day now. Oh, and as far as Bev's jury instruction, about Brennan's mistake.
And for a curative instruction, I'm not going to even consider this today. We can consider this at the charge conference.
That is crazy. Why is that crazy? It's crazy because when an error, and the prosecutor admitted the error, right? He admitted that he made a mistake. The time to fix that is in the moment. You heard about primacy and recency effect. They just heard it. You need to tell them when it happened, because it frames the rest of the fucking trial. I don't think that Bev, if that's the judge's name, I don't want to call her Bev, but the judge, I don't think she really particularly cares for the defense lawyers in this case. And I think she thinks they're carpetbaggers coming from out of town, and she's just not happy with them. Some judges put their thumb on the scale, and they're trying to make sure that the conviction happens, or that the government, gets... You can't be wrong if you rule with the government all the time. Yes, you can. I was just in a trial for 3 weeks where the judge, basically in that trial, whatever government wants, government gets. And it's just disheartening to see that. But that happens with prior, judges who were prior prosecutors. So that's our little update on some key evidentiary points that came up in the last week or so in the Karen Reed trial. We'll continue to follow it, so make sure you subscribe. Follow us on Instagram, follow us on Twitter, sign up for Patreon, and if you're a Patreon paid member, we'll send you one of these lovely trucker hats, and you can spread the word, stop self-snitching. Go to CLRBruceRivers.com for all your merch needs. You can order some art that Michael's created. I highly suggest you do. I put some up in my office, and I really love it. We'll see you next time here in Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that
that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my call.